Welcome to Looking at Legal Stuff. Today we have 3 hearings in a case with a couple where Mama's motioned the court to terminate her back child support payments. She claims she was ordered to start paying child support back in 2007, and she still owes him most of the $30,000 in arrears, but she doesn't think that Dad deserves to get the money because the child didn't live with him the entire time, and besides, he just wastes her money by spending it on his addiction. Dad claims she's lying and says she has a history of making false accusations against him. He says his son did live with his second ex-wife for a short time due to false allegations brought against him, but he still had visitation and he jumped through all the hoops to have his custody restored. He says he continued to have full custody until he was injured at work in 2018. He says he doesn't understand how she can claim he never properly supported his son all those years when she's barely paid $1,500 of the $30,000 in support that she owes. That's just the beginning of the wild back and forth accusations and snarky comments in this case. So what will the judge think? Let's find out.
All right. The next matter is Daniel Thomas and Danielle Thomas, 063-1880. Are you Ms. Thomas?
Yes, Your Honor.
All right, and I don't see Mr. Thomas here.
He's in jail, Your Honor.
Okay. Any idea how long he's in jail?
He might get out tomorrow. He's been in there since February 5th.
Okay, and ma'am, who are you?
I'm Daniel Thomas's mother. He asked us to come so we could try to tell you if it wasn't a no-show, he couldn't get here.
He was served, just so you guys.
No, I understand he was served. And do you think he might be out as soon as tomorrow?
He has a release hearing tomorrow.
I'm sorry?
He has a release hearing tomorrow. He's with Columbia County.
Okay,
He was served in jail, so.
okay. Well, I do think there's proper service. I don't want to move forward without Mr. Thomas when he doesn't have the ability to get here. I'm going to set this to April 17th. That's 2 weeks from today at 9 o'clock. So we'll also hold on to your proposed orders.
Your Honor, may I attend? I work full time Monday through Friday. Could I attend by Zoom?
Yes, you can.
Thanks.
Next, I have Daniel Thomas and Danielle Thomas, cause number 063-188-0. I'll ask if Daniel Thomas is here. Come on up, Mr. Thomas. Either table's fine. Just make sure you're sitting in front of one of those microphones so we can capture your voice and everybody can hear you. Good. Welcome.
Thank you.
And then Danielle Thomas, are you on the line today? All right, I can see Ms. Thomas is there looking for the unmute button, it looks like. So we'll just pause for a second.
I'm here. I'm so sorry, Your Honor.
Okay. All right. So Ms. Thomas is present. We're on today for a motion brought by Ms. Danielle Thomas related to a motion to terminate back child support and a petition to modify child support. I read over the information that Ms. Danielle Thomas provided the court, and I was looking to see if Mr. Thomas, if you had filed anything, and I didn't see anything in the case file when I was reviewing the case over the weekend and this week. Did you file anything by chance?
I haven't filed anything. I got stuff, paperwork showing like when she was ordered to pay child support and all that, and then the recent what I pay because I have kids too that I pay for. So I just got out of jail recently, so it's like that's why I couldn't appear before.
Okay. So you just were recently released from incarceration, and so now you're here. Were you planning on filing something as far as to express your? Because some people do it different ways. One is that you would file your documents so Ms. Thomas could see it and I could read it before we all came here, so everything's fresh in our minds. That's one way to handle it. The other way to handle it is you just give your information verbally here today. And sometimes that works. Sometimes that's not the best because it's new information, not only to me, but to the other side. And sometimes it just doesn't hit right. But if we're given time to look at it, then it's sometimes easier to digest and understand.
Right.
So kind of tell me what your thoughts are with that.
Well, that's kind of it. Just she wanted back child support, not to pay back child support, and just the ruling was, what was it, before 2018, she just started paying child support. So whatever was ordered clear back in 2000 and what was it, 2009.
Yeah. Yeah, so there's the order back from November of 2007 that
Yeah,
created
2007.
the child support obligation that Ms. Thomas was to pay that. And so she's
I believe you were his lawyer, to be correct.
Pardon?
I believe you were his lawyer at one point on this case.
I don't. if
Yeah,
I-
I do believe so. You used to be his lawyer.
I had Chad Andy was my attorney, and then Andrew
Michael
Hoffman
Evans.
was my attorney. That was it in Washington.
There was a Michael Evans. I know who he was. I remember his face when he came on the stand today, or when he came in court today, because he used to be your lawyer, Daniel. I know for a fact. I've got paperwork submitting it. So
Okay, so let me just double check that. I look at Mr. Thomas, I see his name, I hear his voice. I have zero recollection of familiarity with him, and I'm not discounting what you're saying, Ms. Thomas, is that I could have. I've been on the bench since '09, since
I know.
January of '09, and so if I represented Mr. Thomas, I don't remember anything of that representation, whether it was a family matter or
it was very
criminal
brief.
or other. Pardon?
It was a very brief time. You were his lawyer just before Chad Zandy. And you ended up having to it was a conflict of interest because I was also, there was a lawyer in your law firm that was representing me. So you ended up not being his lawyer, and he ended up getting Chad Zandy. I'm not sure how it would played out, if it was Andrea Blondin first or Chad Zandy. But I know you were briefly his lawyer at one point.
Okay. Well, yeah, I appreciate you raising that issue, Ms. Thomas. That's an important issue. I mean, it's an issue of optics. If it's you want the appearance of fairness, I think that's one of the bedrocks of our system. So the concern is that if a person has represented a person who's now a judge has represented one of the litigants in the past, the concern is that there might be some favoritism or maybe actually a grudge. There might be a grudge too. I mean, it kind of cuts both ways, right? I mean, not all attorneys and lawyers and clients are best friends. Sometimes they part ways and they're not happy with each other. So I have zero recollection of anything about Mr. Thomas. And if I did, I would be quick to recuse because I think that appearance of fairness is really important. And if I had any recollection of ever representing him, I would be happy to recuse. But since I have zero recollection, I have completely neutral feelings because sometimes I'll come in and I'll see somebody and I'll recognize them. And sometimes I'll have a very positive feeling because I've represented them or I've interacted with them in the past. And I let people know that. And I say, hey, I have these just positive feelings toward this person, and on the inverse, negative feelings. And I'll share that because I think that's important. Here, it's completely neutral with Mr. Thomas. I'm just kind of here. I don't feel anything one way or the other. So at least from my vantage point, I think we can move forward here today with kind of that explanation and my leaning. If there's any question, I'll step aside for the appearance of fairness because I think it's that important. But here, where I don't have any recollection, I feel completely. I don't have any feelings one way or the other, and zero. Looking at him, it doesn't ring any bells. Not even.
I respect that, Your Honor. I'm sorry. I wasn't trying to be rude.
No. The apology is not needed. I appreciate that you raised the issue because it's an important issue and we need to address it because if you have concerns, we needed to hear about it. And so you shared those and I appreciate that.
Yeah, we can move forward. I'm sorry.
No. I appreciate you raising the issue. Very important issue to raise. So we're here with the motion to terminate the back child support. And I just want to make sure, Mr. Thomas, from your vantage point, what's your response to Ms. Thomas's motion?
So even like with the back child support from October 2007, she's ordered to pay, and then she just started in 2022 paying. Nothing ordered more. And then like with my two kids, I have two other sons. I still pay child support on them. If I get behind, they take it from my check, or I get caught back up. I even have that stuff showing that. But it's like
So hold on, Ms. Thomas.
But she's already paying child support. Then there was a sum for like 220 2 she was trying to go to from 300. Like, so I'm seeing this, but I was just like, she can't get out of what was already ordered back then. So I don't get what she's trying to do. Like, with me, I'm incarcerated. I'm still reaccumulating child support. So when I get out, I still got to find a job. I still got to pay back child support regardless if I have a job or not, or I lost 2 jobs from the same freaking ordeal. You know, it doesn't matter. I still got to work and pay it.
Correct, if you
I
have the
mean,
child in your care. But in this case, Gunner
So,
was
Ms.
never
Thomas,
placed
Ms.
in your care.
Gunner is now,
so hold on. I'm just gonna, I didn't, I usually lay some ground rules, is that I'm really good about letting everybody speak their piece. And so I don't allow interruptions. If one party's
I'm
speaking,
sorry, Your Honor.
they go ahead and finish, and then the other person will have a full opportunity to respond. So, Mr. Thomas, please.
Gunner is now, he's 18, almost 19. So he has moved out. He's graduated school. I mean, now he's out doing his, he was staying with her mom because he was getting into trouble in the county that we were living in, and he just wouldn't listen to me or mind me. He's being stubborn. So he kind of is doing his own thing, and he was living with her mom out in Idaho. And I was like, okay, you can go out there. That'd be better for you to get away from St. Helens, where you've been skipping school, having problems with friends and drugs. I'm like, this is a good thing to get away and hang out with family, even the mom side, because he didn't know that whole side.
Mm.
So recently they started seeing each other. I allowed this a couple of years ago without going through court ordered supervised visits and do it, because I've done that with my kids and it's not fun and it's not good for them. But I just don't get, when I'm in jail, she's filing this stuff while I'm in jail, and then now she's already just ordered it, so I don't get why she's trying to get out of it. Because if I had the money, I'd actually use it towards him, because he's struggling in life too, to find a place to live and get around, and he's been in trouble through things. So it's like he could actually use the help too, and that's what I'd use it for if I got the money.
So let me ask you, there's Ms. Thomas in her motion, she indicates that Gunner was not with you from 2009 to 2024. Do you agree with that or disagree
I
with that?
disagree with that.
Okay. Were there times when he was with you?
So I was married again, but we're not going back over all that. I was married before, and then I went through a divorce, and there was court issues where I had stuff there, and I went through all of it and passed all of that. And that still never changed placement of where Gunner was. Gunner was still taken care of. If it was with my ex-wife, after her, we got divorced, I got married, had another kid. And then he was with her, and there's a point where I didn't have him for a little while because of stuff that was going on. And then after that got all cleared up, then I got him back, and I started doing my normal life. And then I went through another divorce, and I had my other son, Isaiah, his brother. And so I was doing that. And then I had my third son, Hunter. So it's like I was part of all their lives, taking care of them
So
too.
what do you think, if you were to give an estimate as far as amount of time, months or years, weeks, that you had Gunner in your custody from, say, 2009 to 2024?
So I think it was about probably 2 years. There was a gap of maybe 2 years where I didn't have him, but not from when I got custody to him to when he was first born, clear up until now. Like, he went and stayed with his mom a little bit, then he was couch surfing from here to here. But that was after he was 18, or right before, right around there, right when he was 17 and a half, almost 18.
Okay.
And then at that point, the sheriffs, this whole time, the sheriffs have been up my butt. Like, when I got custody of Gunner over here in Washington, like, Washington is totally towards the kid and him being protected and seeing both sides of the parents. And she was just supposed to do a couple things, and she never did that the whole time. And then she still sees them. They're like, with me in Oregon, like, I have my kids, and I've only lived over here 9 months, got a DUI over here, still got full custody of my son, right? At that time, and my brother died, still got full custody of my son, still able to raise him. And then I see that she's even getting help from the state and everything this whole time with her other kid that's autistic. And I'm like, man, all these years knowing that she had a kid that still had the same struggles like my son does, and I could have had that support in school, because like trying to deal with IEP and deal with the teachers and being a guy trying to deal with this, you wouldn't believe how much garbage it was just to go through to even get them to understand him, and not like, oh, just pass him off so he gets an education, you know. I even brought him to work with me, took him to work, showed him different types of jobs I did. He got on the job training.
Okay.
So it's like, he's a very well-rounded kid.
Mhm. Okay.
But I mean, I've raised him. I mean, you can ask him too, but it's not, the whole thing isn't about the money. That was ordered just like me. It's ordered whatever, if it's minimum wage, or if I made $20 an hour, that's all I've ever done in my life. I mean, you can only take so much. Like with her, it's the same thing. She has other kids, but even what she's applying for, like, she's claiming food stamps for Gunner. Well, Gunner was there And then he needed that, and he didn't even have food stamps. He couldn't even get it when he was couch surfing. I'm like, well, here, I'll help you out. But
No.
things like she's doing there, and then saying that her girlfriend is her sister. And that's not even her sister, that's her girlfriend. That's living with her. It's like,
Okay.
and then she changed her last name back to Thomas towards the end of when was this, in 2022, 2023, when she was married already before? I don't get why she was even doing any of that, like, to go back and forth with your last name. When you had 3 other kids prior, why don't you keep one of those last names and go back to your first kid? I don't get the whole cause of that.
All
And
right,
in the state of Washington, when this first went, she was found out to be lying, being a habitual liar. She was found in these courts to lie on record.
All right, so let me, before I hear from Ms. Thomas, so this is kind of what we were talking about at the initial get-go, is that I've had an opportunity to read what Ms. Thomas has to say. You've had an opportunity to read what Ms. Thomas has had to say. And then I get to hear for the first time kind of what your viewpoint is, and Ms. Thomas gets to hear for the first time kind of your official viewpoint at this point. So to be honest, it's a little hard to take in, because traditionally when I prepare a docket, I'll read both sides, right? And then
Yeah.
I'll have an opportunity kind of in the calm of my office to kind of weigh things left and right. So I'm kind of the opinion of, because you raise a lot of important issues that I haven't given much thought to. And if I do it on the fly, I don't necessarily know if that's the best way to proceed. So I'm kind of leaning towards giving you an opportunity to submit documentations, a declaration to kind of spell out and support your positions. So I can see that, and Ms. Thomas can see that. And if she wants to reply to that, then she could submit some documentations of giving her viewpoint on what you had said.
Oh yeah, and I was just able to get my taxes done to show my last 2 jobs of the last year and everything too. So it's like, I just got this together before the court date, and I have it here, but I just didn't
So,
submit it.
Right, Ms. Thomas?
So,
Go ahead, Ms.
so
Danielle.
you're giving him a chance to get his stuff together when we've already been to court 2 weeks ago and he was a no-show, and I called the court, or I called the courthouse where he was at court. They said he could have been there via Zoom. So now we're taking this out another 2 weeks or however long, because we've got to get proof of what? The fact that he didn't have our son, the fact that he's misusing my child support money that I'm currently sending him on his addiction. What are we doing? This is not okay. I'm not okay with it.
Okay.
And I guess that if we have to, I will do the proper antics to go and channel how I need to, if I don't agree with this court hearing.
Right. Yeah.
Or I
So,
would just rather have you stricken off as a judge, because I feel that this has gone on too long and I'm just tired of it. He's taken the money that I'm giving him every month that I could be using for my disabled children. And you see I submitted you evidence after evidence of what he's doing with the money, of petitions, of declarations. And you're just gonna be like, oh, Daniel, let's waste Daniel's 2 weeks and get proof that you don't need. I'm so frustrated, Your Honor.
yeah, I hear your frustration, Ms. Thomas. One of the bedrocks of our system is due process. Due process is basically comprised of an
And he
opportunity
knew
to
that.
have a fair hearing, which means notice and opportunity to respond. So
Okay.
opportunity to respond, there's a lot of times there's default judgments that happen where people just don't show up, and so we just sign defaults. There's oftentimes life is not a clear cut from point A to point B. And so generally we try to err on the side of giving everybody a voice, because if people feel that their voice is heard in court, then they feel like win or lose, they feel that they got a fair shake. And that's really what the system is about, is giving opportunity for every voice to be heard. It does have to be, are there some reasonable time limits on that? Sure. You're talking about a 2-week set over, maybe a waiting a month for issues that stem back from 2007. I think that's reasonable. I think a 2-week set over is a reasonable period to allow you the opportunity to hear what Mr. Thomas has to say and allow him an opportunity to say, and for you to rebut that. I think it's reasonable that 2 weeks is not bending over for anybody, especially when you're considering the request, which stems back to 2007. So I'll set the matter over to the.
Can I have a different judge, please? I don't want you as on my case.
It's too late. You can't get a ruling and then say, I want to switch. So at this point, no, that request is denied. So I
Okay.
made it because I made a discretionary decision to continue the matter prior to that request being made, and the prior record which I had made on at the beginning of the hearing indicating zero recollection of any representation of Mr. Thomas. I also checked the case file for notice of appearance, which all attorneys do if they represent somebody, and I did not file that, at least in this case. So if we can set it over to 2 weeks, May 1st, we're not available. That's judicial conference. The following week is available, so that would be on May 8th. So we'll
So
set
what-
it to Wednesday, May 8th at 9 o'clock in the morning. And Mr. Thomas, if you want to respond in writing, you'll need to submit your documents to the court with declarations supporting them, and then serve those or give copies of those to Ms. Thomas. And then she would have an opportunity to respond and file her response, and she'd have to give you copies of her response and file hers with the court.
So which address is she using? There's 3 different addresses on that paperwork.
Daniel, you have my address. Don't act like you don't have
Gunner,
my
you
address.
text
So,
me
so,
your
so, so,
address.
wait. We're not going to do this.
Yeah.
You both, when you speak, you'll speak to me and to me only. You will not speak to each other in the hearing. So what I show here is that Ms. Thomas used an address in Portland on Couch Street.
That's correct, Your Honor.
That's the most recent filing. That's where documents can be sent for her review.
Now, can I ask a question?
Please.
So I do apologize for my frustrations. I want to start off by saying I'm sorry.
It's okay. It's fine to be frustrated.
I'm really, so I've got 2 kids that have disabilities. And as much as I hate, like, I am struggling myself. And so it's just like, I guess maybe I don't understand what's going on. Like, I don't get what, are you just giving him the opportunity to kind of like,
We're giving him an opportunity to have his voice heard and for you to respond to his position. So the court will be well informed of what the issues are from both perspectives. And
now, if I needed to get his ex-wife subpoenaed into court due to the fact that my son was with her for an extended amount of time, several years to be exact, then this is the time that I can do that if needed, right?
So generally, these type of hearings, they're done on declarations or written documents. So if you want to submit any documents, you can. You need to make sure that copies are given to Mr. Thomas so he can respond also.
Okay, so written declarations, is that correct? I'm just trying to understand, Your Honor, that's all.
Yeah, that's
I'm
how
so
people's
curious
voices are heard.
how I was served while I was incarcerated. When I was in St. Helens, Columbia County Jail, I got served this paperwork inside the jail, and they wouldn't even let me appear video WebEx or calling in or nothing. So I was like, how was I getting served while I was in jail?
So it's not uncommon. People are served while they're incarcerated. That happens with some regularity. I see that regularly.
Yeah.
So you'll have an opportunity to submit your documents, and then we'll be here on May 8th, 9 o'clock.
All this from up in 2007, 2022 was already ordered past then in 2007 when Chad Zandy had it. I believe that's when all this was ordered. And then just like, I'll submit this. It shows that she's supposed to be doing $320 a month. And then the state finally caught up to her when she changed her last name from Hudson back to freaking Thomas. And then now she's owed this. So.
Right. So these are all issues that we'll talk about on May 8th.
Okay. And I'll just submit all the stuff I have from Washington and all that.
Yeah. Whatever you feel is appropriate, you can submit that information and Ms. Thomas can supply her response to it.
Do you have a copy of the court date?
May 8th, we can write it down.
I didn't bring a pen. I forgot one.
Sure. All right. So we will see everybody on Wednesday, May 8th at 9 o'clock in the morning.
Now, there is one more question, Your Honor.
Yep.
I did file my tax return, and I have filed the conference board to have them give me half of my taxes back. Currently, my son is very sick, and I've got medical documentation supporting that I need that money for my son. Is there any way, like, you can, there's really no way you can do anything until you have your ruling. Is that correct?
Yeah, for the court to make a decision on any issue that's important to the parties, both parties have opportunity to raise it and have their voice heard, and then a decision would be made. So any decision related to taxes would be premature today without both parties having an opportunity. So if that's something you think is important, you can certainly raise the issue via motion and note it up for a docket and give Mr. Thomas an opportunity to respond.
Okay, now, since I'm self-representative, you said write it up for what, Your Honor? A motion?
Yeah, anytime anybody asks for something from the court, they want something, then it's usually brought forward in what's called a motion. A motion is just a request. It's a petition, it's a request. So generally,
Okay.
it's if a person is asking for a motion for more parenting time, they'll say it's a
Okay.
motion for more parenting time, or a motion to change child support, or a motion to do X, Y, or Z. Okay.
Fair enough. Thank you, Your Honor.
Any questions, Mr. Thomas?
No.
Okay, we'll see everybody on May 8th at 9 o'clock in the morning. Thank you.
I don't know how to log off, Your Honor.
That's okay, I can help.
Thank you.
Next, I have Daniel Thomas and Danielle Thomas, 063-188-0 is the cause number. And it looks like we have Mr. Daniel Thomas in the courtroom. He's coming forward and taking a seat at council table. And is Danielle Thomas on the line?
I'm here, Your Honor.
Okay, great.
I do have to I am currently washing my daughter's hair. So I'm just gonna finish that, but I am here.
You said you're doing what with your daughter's hair?
My daughter's in the shower. She's 9 and I'm just rinsing her hair out. I didn't know I was gonna be called yet. I apologize. But
Okay.
I am here.
We'll call you a case once you're finished with helping your child. How long do you think that'll be?
Like 2 minutes. The
Okay.
next case, if you can, Your Honor.
Okay. Mr. Thomas, you okay? Just waiting one more case and then we'll call your case.
My apologies.
Sure.
Okay.
I mean,
Well, let's do that. Get the girl out of the shower and get her prepped and ready to go, and we'll call your case in just a second. Next, I
Thank you
have,
kindly.
all right, let's go back to Daniel Thomas and Danielle Thomas. Mr. Thomas is still here. Ms. Thomas, can you hear me?
Yes, Your Honor, I can hear you.
Okay, you ready to go now?
Yes, Your Honor, my apologies.
Okay, thanks. All right. So we're here on Ms. Thomas's motion to modify the back child support. We were here previously, and there was additional information that was provided. So I'll hear from you, Ms. Thomas, first about your motion, then we'll hear from Mr. Thomas in rebuttal. Go ahead, Ms. Thomas.
So basically, my motion is the reason I am requesting to terminate the back child support is because Gunnar was not in his father's care a majority of that time. And I've paid over 3 years consecutive of child support. In addition, Daniel gets my taxes. So what I've learned over the course of this last year is the money that I'm sending for child support, Daniel's just misusing the funds. He has an addiction. He has
objection, hearsay.
The objection's noted, overruled. Go ahead.
he has been arrested twice within the last 6 months due to alcohol and violence.
Objection,
Basis?
she's just talking. She doesn't even know what's going on with the case.
Objection's noted, overruled.
And-
Go ahead, Ms. Thomas.
And I can.
Go ahead, Ms.
before-
Thomas. Go ahead, Ms. Thomas. You'll have an opportunity, Mr. Thomas.
And so I feel that the money that I'm sending isn't going towards Gunnar's needs, isn't going towards Gunnar at all. The money's just being used for Daniel and Daniel's needs. Gunnar has been in my care majority of the time. I've provided 2 years taxes. In addition, I've provided, everything that I've provided to you with the court's declarations. And I just hope that the stuff that I've provided you've really considered. I have 3 children that I support, 2 of which have autism and disabilities. I am still currently helping and supporting my son Gunnar, even though he is of age and 18. And this is just, it's just a very challenging situation, especially when I know that I feel as though I'm paying him child support for no reason. You know, that's how I feel. And the money that I am sending him, he's just not using it the way it should be. And that's really all I have, Your Honor.
Ms. Thomas, you mentioned that your position is that the child has not been with the father the majority of the time and that you've been
That is
paying
correct.
child support. Did you calculate an amount of the arrears that you believe should be modified or forgiven?
So I have paid over, when I first started paying child support, it was close to $30,000 in back child support. I am now down to, I believe it is $2,150. So I've paid a considerable amount, almost 10,000 in back arrears. And for the time that Gunnar was in his father's care, I do feel that the arrears have already been paid. And so I'm just hoping that the court is willing to forgive the 2,150 remaining.
So you're indicating, so there's a child support order that was entered in 2007 that requires you to pay $222 a month.
Yes,
And then you indicated that that Gunnar had not been living with the father from 2009 to 2024, but there
That
were
is correct.
periods of time where he was with the father.
yes. I mean, there were periods of time where he was with the father. Yes, I'm not denying that. Absolutely.
Like what amount of time are you talking about?
I know in 2000 and let me get my paperwork. In 2000 and maybe 9, I know that he was with his father. He just got reintroduced back to being with his father after the whole court situation. Daniel was not allowed to be in the care of any minors. So at that time, Daniel's ex-wife got custody of our son, Gunnar. Temporary, it was like a temporary guardianship because there were some issues going on. And Gunnar was with Nefe Thomas for 6 years of that time. So that was in 2000. I'm getting my paperwork right now. Then Daniel did get Gunnar back about 6 years after he was taken. And he had him for, I would say, about a year. And then Gunnar decided to go stay with other people, which was his grandmother, because him and his father, he's scared of his father. He has a hard time being around his father. He's intimidated.
Objection.
Basis?
This hearsay of what she's saying, she can't speak for him and he's 19. He's 19.
Objections noted, overruled. Ms. Thomas, can I ask you a question? So you're saying that Gunnar was living with dad from 2009 to 2015 under the guardianship?
No, he was living with dad from 2000, and I got my court paperwork right here, Your Honor. I am so sorry. He was living with his dad from 2009 to 2010, and then went and stayed after 2010. It was like the next school year. He went and stayed with his grandmother. Then he went and stayed. He stayed there for 3 months.
Basis?
Then he went. Then he went and
Hold on,
stayed
Ms.
with.
Thomas. Hold on, Ms. Thomas. There's an objection by Mr. Thomas. Basis of the objection?
There's almost 2 years where he wasn't in my possession. I already had full
So
custody.
an objection is just a short statement of what the basis, like hearsay, like you've done in the past. If you're wanting to provide additional information in your version of the events, when it's your turn, you can provide that additional information. So go ahead, Ms. Thomas.
Okay, so then he went and stayed with Tony Harris, which was his father's ex-girlfriend. And he stayed there with her for about a good year, I would say a year. And then that's when he was returned back in my care and came and stayed with me. He's been with me since 2018.
So there's a gap there. So 2009 to 2010, Gunnar was with father. And then from 2010, he was with NAF, N-A-F-E.
No, yes. He was with Nefe.
Until when? 2010 until when?
2000. So, okay, let me see if I'm, So Gunner was, when he was with Nefe, he just turned 7, and that was he was with her for 6 years. Daniel,
Okay,
um,
2010 to 2016.
yes, because the state of what was St. Helens provided legal guardianship to her, and then after Daniel had proved himself to the courts, they allowed Gunner to go back and do like weekend visits for an extended amount of time. And then after so long, it was about I would say a year, he was put back in Daniel's care. He was in Daniel's care for about a year before he ended up leaving Daniel's care and staying with other people.
So what was the time frame you spent a year with Dad?
Okay, so that was in 2000 and I would say 2009 or 2010, if I'm not mistaken.
Okay, so that's what you said earlier. And then at age 7 in 2010 to 2016, he was with NAFE. And then
Yes,
2016 forward, he's either been with you or others.
yes, that
That's your
there
position.
is a gap that I am not accounted for because that's where my son was staying with his friends. He
Okay.
did run away and go stay with other people.
So the question I have, Ms. Thomas, if during that time when the child was not with the father and you were paying child support, why didn't you bring a motion to end the support obligation since you knew that he wasn't with the father?
Your Honor, I had an addiction problem. I got clean February of 2018. And at that time, I didn't know that I was able to do so. I had no knowledge of any of this until after I got clean and started researching and kind of figuring out what my next steps were.
In 2007, when the order was entered, the child support
Yes.
order, did you participate in that?
Yes,
Okay, so you're aware of the order and okay. All right. Okay. Anything else you want to share?
no, Your Honor.
Okay, we'll turn the time to Mr. Thomas. Mr. Thomas.
Thank you.
So since I got full custody of Gunner, I've taken care of him. She did nothing to help except to make it more difficult and make false accusations, filing reports. So for over 18 years, I've been coming in and out of the courts. I do have 2 other kids with 2 other women. And Gunner did stay with his mom. I did get in trouble until I had to prove my innocence again, or prove my side of everything, because that's all I spent is just defending my side instead of just raising my kid and having support. Like she's had support from the state for her kids that are autistic and all this. So I'm a single dad raising this kid, putting him through school, knowing he has problems. She couldn't be around to help because she has 3 other kids that have all these problems. The state were, hey, we can help you with this kid. You can't leave him at home, but yet you're supposed to be at work. So I did all that myself, and she popped in and caused this garbage. With my second wife, I did lose Gunner for a little while. I got him back. He was with my wife, which I had another son with, and he was fine. And after that, I got him back and I had him. And I raised him up until, well, I guess 2018 is when she started getting clear. 2019, I got hurt on the job. Got my kids taken from me because I got hurt on the job. I could be a provider and take care of my kids and see them and be every part of their lives. But then if I get hurt being a provider and I can't even go to work, they take them from me, you know? And then they're garnishing me $750 a month right now just for child support on kids I don't even see anymore. You don't even talk to. I don't have rights to, but yeah, I can raise a kid. And then now she's like, I'd even take care of him this whole time. That's not true. I showed you the paperwork. She's only paid child support, maybe the most of $1,500 is all she's paid in child support. And that's recently, that's all submitted in the court. I didn't have all that submitted last time. It's not about the money, it's about her being a part of his life. He started getting introduced to her. He started skipping school. He started going out and doing drugs. When he started getting his driver's license, he started buying past me because I wasn't going to let him get his license because he wasn't good enough behind the wheel because he didn't pay attention. I wasn't comfortable with it. As soon as he turned 16, he knew he wasn't good at his license, went around me, went to his mom. and he pulled that card. So there was all that stuff going back. And if a woman says anything in Oregon or in Columbia County, they'll just automatically grant it and assume it's set in gold and stone. That's how they are.
What's your position? You heard me ask questions about kind of timeframes of when the child was with.
So in
Can you provide
2009,
me some information related to that. I'll finish my sentence before you interrupt.
sorry, 2000, I believe it was 2010, there, from 9 to 2010, there's about 2 years where I couldn't be around the kids until I went through the court process. Somebody made an allegation about me, cleaned it all out, and I had my kid back. And then at that point, I went through a divorce because of that process caused me to have a divorce because of.
So would that be
stipulation.
about 2009 to 2011 that they had the difficulties, and then kind of walk me through your timelines?
I can get the date from my mom because she was there. She remembers the date. She's right here. She's gone with me to all these courses. I don't understand the dates and paperwork because I struggle with that stuff, but.
Okay.
One
So-
day,
So there was a period of time where there were some restrictions or you weren't able to see her. So I didn't give you permission to speak. I apologize. So there was a period of time where you couldn't see them because some legal issues, and then the child came back to Gunnar came back to you.
yes.
Okay.
So, and that
And
time
then-
I wasn't not seeing them. I had to have supervised visits. So I was going there every week
Okay.
and every other week and seeing them, spending time with them, doing everything I could, just because somebody made an allegation. It wasn't true. Went through all the stuff. I had to go through this process and the courts got involved. And this is like what you have to do. And so we did, and we got through it.
Okay. And then after you got through it, then how old was Gunnar at that time when you came back into your care,
He was,
or what grade?
what was that? Not even middle school. I mean, he's just in, it's before
Yeah.
high school
Okay. And then how long did you have him in your care?
the whole time. And then I didn't, then I had him in my care the whole time until recently where, he was old enough, and actually the state came in when she got involved where he wasn't even going to school and he had skipped in school. And then she was showing up there at school his senior year, and he was supposed to stay in school and actually graduate and get a better than a 2.0 GPA graduating school because he was on a modified diploma and a IAP. I mean, he had struggles in school. The kid did a lot. Like I could
So-
take him to school and drop him off at school, and then he'd just leave.
Yeah. Let me ask you a question. Ms. Thomas said her recollection is that from like age 7 to about age 13, between 2010
No.
and 2016, Gunnar was with NAFE or with somebody else other than she or you. What's your position on that?
No, it was 2 years, and my mom can say the dates if you allow her. She knows the exact dates, and I had the paperwork.
And that was 2 years with NAFE?
No,
or
yeah.
NAFE, okay. And then, so your position, so that happened sometime after 2011, so I'll put 2 years with dad, and then what?
And then he was back with me, and I raised him and had him in school and just going to work and taking care of him. No
Okay.
support from her.
Okay. All right,
And then I had my other son Isaiah, and I was seeing him every other week.
okay. And then I saw you filed tax returns showing that you claimed tax exemptions for 2021 and 22, or 2022, 2021. Okay. Okay, all right. Thank you. Ms. Thomas, any additional response?
No, Your Honor.
Okay. All right, thanks. I appreciate the party's patience and kind of your input and kind of walking me through your respective positions. It was a little challenging for me to understand the pleadings. So I appreciate the added input today. So there was a child support order issued back in November 2007 requiring Ms. Thomas to supply child support in support of Gunnar to Mr. Thomas. And that was to start in October of 2007. So there's been an accrual of back child support that it remains. Mr. Thomas indicates that Ms. Thomas has probably paid tops $1,500. During a period of time, Ms. Thomas was struggling with addiction and was not doing very well. And it sounds like during that time, Mr. Thomas was the one that picked up slack. Neither him or his mother or Nafe was in a position to help provide care to Gunnar. Ms. Thomas was present for the hearing in which child support was ordered. And when asked about whether, what was her reason for not seeking child support modification when the child was not in Mr. Gunnar's, or pardon me, Mr. Thomas's care, indicated that she just didn't do that and wasn't aware. So I think here I'm going to deny the motion. There's a real lack of detail of what the dates are and what the amounts are that she's paid or hasn't paid. And so really there's just a failure of meeting the quantum of proof. So I'm going to deny the motion.
So now how do I appeal it?
You can file a notice of appeal. You have several options. One, you can file a motion for reconsideration that has to be filed within 10 days. And then
Done.
thereafter, once the court has submitted its written ruling, you have 30 days from that point to file a notice of appeal with the Court of Appeals.
Now, can I ask you since I still have to continue to pay child support until I can get this straightened out and get the dates straightened out, is there any way where you can have it to where my taxes aren't taken? I do have other children.
So related to that, if you have a separate request, you'd need to bring a separate motion asking for whatever relief you're wanting, serve Mr. Thomas a copy of it, and you'd have an opportunity to reply.
Okay, so now okay. And then how do I make sure you're not the ongoing judge?
At this point, the rules are that when a judge has made a discretionary ruling, which I've done here today, then prior to that, before a judge makes a discretionary ruling, any party has the right to file what they call a notice of disqualification, or sometimes they refer to as an NOD. Anybody can do that prior to the court making a discretionary decision. Once the judge has made a discretionary decision, you can't kick that judge off with a notice of disqualification, because the idea is that judges make decisions that people disagree with all the time, about 50% of the time. And so the idea is to avoid judge shopping. And so at this point of time, if you file a notice of disqualification, it would not be honored.
Because okay. So then I'll just appeal it, do what I need to.
Okay. All right. So I will submit the order denying the motion to modify the back child support, and that'll be filed. If either party needs a copy of it, you can get a copy of it. Okay, that'll conclude the hearing. Thank you.